Well, Skydrit is there, so we can start. Welcome to this second panel today, and our main task is to prevent you from falling asleep after this nice lunch. We have a very distinguished panel sitting here on the podium, so let me briefly introduce the panel members. We have Professor Alison Jones, who is a professor of law at King's College London and a solicitor at Freshfields. And she has taught, among other things, competition law and EU law, and publishes widely on competition law and cartels. And by the way, she recently won a prize with Konkurences for best competition article, so congratulations on that. And then we have Professor Mike Kramer, who is from the United States, Washington, who is an attorney at law and more importantly, a former prosecutor at the Department of Justice, investing in particular crime in bid rigging. He's also the co-founder of the International Anticorruption Resource Center, which is a recent creation, and he has, for the last couple of years, investigated corruption in international development projects, notably for international organizations such as the UN and the World Bank, and he is the author of books, articles, and software programs on fraud, money laundering, and computer fraud, and he will talk about detection methods. Then we have Dan Sjöblom, not unknown to those of us from the competition European competition world. He is the Director General of the Swedish Competition Authority since 2009, and before that he worked he was a colleague at the European Commission, and his last function before moving back to Sweden was head of the merger control unit for energy. And then finally we have Jasser, who is the president of the Polish Office of Competition and Consumer Protection. Before that, he was a Secretary of State in the Chancellery of the Prime Minister, and coordinating the government's legislative agenda in areas such as economic policy, pension reform, business environment, and energy. And he's also a former journalist. So before giving the floor to the speakers for the panel, I was asked to say a few words about cartel enforcement at European level. So that's what I will do. And then we enter into the heart of the panel discussion. Well, our fight against cartels is a constant priority at the European Commission. And last year was a year with extremely high outcome, in the sense that we took the final decisions in 10 cases and imposed a total of 1.7 billion euros in fines. Now, I was having a discussion yesterday with Bill Kovacic whether these 10 decisions were meaningful or not. He said it was like having a menu of 10 dishes. You never know whether they are good or not. But I think it's a sign of at least strong deterrence and strong enforcement. And they were in important areas where there are really cartels going on that I think are doing a lot of harm to the consumers. Notably, for instance, car parts. I mean, everybody has a car, and if you look at the interior of a car, I can tell you lots of the parts in your car are being the subject of cartels, and we are investigating a lot of them to make the cars cheaper, of course, but also financial services, and the famous LIBOR and Euribor cases were the subject of our decisions. Now, what was interesting in these 10 cartel cases is that 8 out of the 10 were concluded through a so-called settlement procedure, which means that the companies admitted guilt, cooperated in investigation, and in return got a 10% reduction on the fine. And this is a procedure that was introduced only recently in 2009, and in the beginning there were some doubts whether that was in particular, this 10% fine reduction was a sufficient incentive for firms to cooperate in these settlement procedures. But I can safely say now that after 5 or 6 years, this is definitely the case. In almost all our cartel cases, we see that companies want to cooperate, and so there's a large majority that is now concluded through settlement decisions. And even if for one reason or another we cannot conclude it through a settlement, of course we follow the normal route, or sometimes also hybrid cases where part of it is done through a settlement and part through the normal procedure. Now then, in terms of deterrence, I think there was a very important development last year when it comes to cartels in particular, and that is the adoption of a legal instrument, directive concerning private damages for victims of competition infringements, and of course notably cartels. This has by some journalists has been called the ultimate democratization of competition law. And of course, in some countries, such as in the US, there's a long tradition of private enforcement of competition rules, but not so much in Europe. And so I think this damages directive that will allow victims to claim compensation is a very important step forward. It was adopted at the end of last year, and the member states have 2 years to implement it and to integrate the possibility to get compensation into their national legal systems. And for some member states, this is not an easy task because in only a little bit more than half of the member states, such a system of damage compensations was actually existing beforehand. But in all the other member states, it will have to be introduced newly into their legal system. And that, of course, bears the question whether these kind of compensation mechanisms should be introduced only for victims of competition infringement, or also of victims of other type of infringements, for instance, against labor law or environmental law or so. So we are following very closely this transposition process, which is going well. There are only 4 member states that so far haven't started the process. But other countries such as Latvia have already made significant progress, and I think this damages directive will ultimately have a strong impact on enforcement. The one element that is not covered by this damages directive is so-called collective redress, or mass claims, or class actions as they are called in the United States. The Commission, European Commission, when it made the proposal for this directive, it decided that it was better to, in the first stage, make a recommendation to the member states to introduce this type of claims in their national systems, and then it would review it. So several member states have actually taken up that recommendation and are indeed introducing such possibilities for collective redress in their legal system. Some others don't. And this will be evaluated at some point in time. We announced 2 years after the adoption of the recommendation. Now let's move to the topics of this afternoon, and we will mainly be focusing on 2 issues. One is on information exchange, the role of information exchange in cartels and collusive behavior, and Alison will give us a rather complete picture about all the issues at stake here. So I don't want to say too much about it. What an important question here is, when you have competitors that exchange information that are not really typical cartel decisions, like deciding on the prices or deciding on the volumes, but that can lead to such type of decisions, is this then an infringement by what we call by object, so for which no further proof is needed, or is it an infringement by effect? And there was a very recent judgment by the Court of Justice dating from March in the Bananas case, where the court actually decided that communications between competitors leading to horizontal price fixing are anti-competitive by their very object. So this is, I think, a very important part of the jurisdiction now, and it actually was building on previous case law. So I think Alison will say more about this. Now, second important topic, and that's why Mike is here, is about the ex officio detection of cartels. We heard this morning that many cartels are being detected by leniency, but there are certain type of cartels that where for one reason or another the participants do not engage easily in leniency. Sarunas was saying at the press conference, perhaps because this is not considered to be morally abject to be participating in a bid rigging or so in particular in bid rigging, one may see less leniency applications than in a classical cartel. So the issue of ex officio enforcement remains important because leniency will not work if there's not also a chance for a cartel to be detected. And of course, more and more procedures are becoming, and means of communication are becoming electronic and more difficult to detect. And so Mike will talk about how one can detect ex officio cases also, for instance, when there's electronic procurement. Then we have Adam and Dan who will speak. So Adam will be looking at cartel detection methods and sanctions in preventing infringement, and he will talk about the experience in Poland in particular regarding public procurement, and Dan will then follow by discussing cartel screening project in Sweden, where simply by looking at circumstantial evidence, if I may call it like that, you can see whether there's a prima facie case for a cartel. So I think very interesting topics, very topical, and I'm looking forward to the presentations. Alison, please start.
Thank you very much for that kind introduction, and thank you very much to the Latvian Competition Council for inviting me to speak here today. As Mr. Taliana said, I'm going to talk about information exchanges, and I'm going to talk about standalone information exchanges, where the main point of the communication between the undertakings involved is to exchange information, so not information exchanges which might be part of a mechanism of bolstering a cartel or part of some sort of broader cooperation agreement. And I'm going to talk about how they are analysed under Article 101 of the treaty. So I'll start off, and I'm going to introduce some of the challenges here of antitrust analysis, how we analyse them, whether we treat them as restrictions of competition by object, and if so, when. How do we, are these information exchanges caught at all by Article 101? Do they result from joint or actually have they resulted from unilateral conduct which falls outside 101? So just a first point to mention about information exchange is we've had a little introduction to cartels in the introduction to this session. These are agreements between firms which are specifically designed to interfere with competition, eliminate the main parameters of competition between the players. They don't generally have any offsetting benefits, and they are treated as presumptively illegal under the competition law rules and punished severely if and when they're caught. Information exchange agreements may be designed to achieve a whole array of pro-competitive objectives. They might produce benefits to consumers because they provide information to consumers which helps them make decisions, or it might provide benefits to consumers by allowing suppliers to improve their commercial strategies or internal efficiencies. So there are many beneficial and pro-competitive information exchanges. On the other hand, as has been alluded to in the last session, there are some information exchanges which can be problematic and some which may be very problematic, and those are particularly where the information exchange is being used as a more amorphous mechanism for the firms to coordinate their behaviour on the market. So the biggest concern about information exchanges is that they will be used as a mechanism for coordinating, or in a way that facilitates collusion between firms operating on a market. So for collusion to work successfully on a market between independent firms, normally three things need to be able to happen. First of all, firms need to be able to find a way to align their behaviour. But for the collusion to work, there's got to be internal stability. Firms mustn't be able to deviate from the collusive outcome and cheat on it without being detected. And the collusive strategy mustn't be undermined by new entrants coming into the market. And the concern, a core concern about information exchanges is that they will, as I say, be either a mechanism for coordinating collusion on the market by allowing the parties to align their behaviour, or perhaps operate to facilitate collusion by increasing transparency on the market, making it easier for the firms on the market to see how their competitors are behaving, whether they're losing market share vis-à-vis their competitors, whether new entrants are coming into the market, etc. So information exchange, as I've said, can cover a whole array, spectrum of different type of conduct, ranging from clearly quite bad to potentially very pro-competitive, and some which is more difficult and fact-specific to determine its impact on competition. So what does this mean for antitrust analysis under Article 101? And I think what the position in the EU is that we do apply a quite strong presumption of illegality to certain types of information exchange. And these are increasingly being treated as quasi-cartel-like behaviour. But outside of that area, there are relatively few bright line rules for businesses to adhere to. And actually, the question of whether the information exchange is likely to restrict competition within the meaning of 101 or satisfy the conditions of 101.3 is likely to be a quite require quite a fact-specific analysis of the market and the actual information that is being exchanged. So turning to the first category, on my previous slide, is that there is an increasing concern that some information exchanges are being used as mechanism for firms to be able to engage in joint fixing of their prices or output. So as leniency applications rise and the detection of cartel meetings in which firms get together and agree to fix prices, restrict output, detection of that type of conduct becomes more likely, then perhaps there's a greater incentive for firms to find more amorphous ways of communicating to each other and coordinating their behaviour. So in its horizontal cooperation guidelines, the Commission has said since 2010 that they think that if you engage in information exchange with your competitors about your intended future conduct regarding prices or quantities, then you're providing private, confidential, disaggregated information about what you're going to do in the future, then this is tantamount to sort of cartel conduct, and you run the risk of the conduct being investigated and fined as cartel activity. And the challenge often in these situations is because the exchanges might be a little bit more amorphous, informal arrangements one of the other challenges might be to actually work out whether there is any joint conduct which falls foul of Article 101. So Article 101 and 102 draw a fundamental distinction between joint conduct, which is caught by 101, and unilateral conduct, which is the principal focus of Article 102. So information exchanges are only caught if they result from joint conduct on the market. Now, what Article 101 makes clear is that Article 101 doesn't just apply to agreements where firms have a concurrence of will about the prices, the output they're going to set. It applies to a broader range of category, not only decisions by associations of undertakings, but importantly in this situation, concerted practices. So for a concerted practice to exist, there doesn't actually have to be any actual plan to sit down and fix prices. Concerted practice catches a broader range of conduct where the parties knowingly substitute practical cooperation between them for the risks of competition. So it's getting at direct or indirect conduct which is designed to influence the conduct of your competitors on the market, or perhaps to let them know how you are going to behave on the market. So that can certainly catch reciprocal exchanges of strategic information between firms. It can also catch unilateral disclosure of information by one firm to another, even if they don't reciprocate, if that firm has requested the receipt of the information or tacitly accepts it. And it seems that this concept of a concerted practice can also catch the situation where information is exchanged not directly between two competitors, but perhaps through the intermediary of a third party. So hub and spoke, or what are known as ABC agreements. So retailer one tells its supplier that it wants to raise its prices on the retail market, and the supplier passes that information down to other retailers operating on the market. So in certain circumstances, you might be able to establish a concerted practice between the two retailers and the supplier, which is operated through the hub, the supplier in that situation. So all the cases I've put up on this next slide are examples of cases at the European level or the UK level where information exchange has been treated very severely by the competition authority when they have discovered it, and where the findings of infringement have been upheld, in the bananas and the replica football kits cases by the court. So we've already had a brief discussion about the bananas case, but this concerned bilateral exchanges of information relating to price-setting factors between the banana suppliers on the market. They didn't actually specifically discuss the prices, but what the Commission found and was upheld by the court was that the information they exchanged did eliminate uncertainty about their future pricing behaviour on the markets, and was a mechanism for fixing the development and evolution of prices. RBS and Barclays is a case in the UK which was settled where RBS unilaterally disclosed information to one of its main competitors, Barclays. Barclays didn't provide information back, but they received that information and carried on acting on the market. And the UK Competition Authority agreed a settlement with RBS, who agreed to pay £28 million as a result of this behaviour. One type of conduct which has been challenging a number of competition authorities in recent years is what to do about public exchanges of information. The cases I discussed over here were either private exchanges between the players or information which was exchanged through the intermediary of a supplier. But what if one competitor simply announces publicly that in 6 months' time it's going to raise prices, and its main competitor reciprocates with a similar announcement? To what extent can this conduct be caught? And this really goes to the breadth of this concept of a concerted practice. And the case law indicates that these would be pretty hard cases to try and bring under Article 101. In the wood pulp case, the Court of Justice held that the price announcements made in advance in that case by the pulp producers were not evidence of a concerted practice because there was another plausible explanation for what they were doing, which was that they were providing information to consumers, the buyers of their wood pulp, who needed this information to make their long-term planning for operations in the paper market. Nonetheless, it is a space to watch. It does attract attention by competition authorities. I know the European Commission is looking at public announcements in the container line shipping. The Dutch mobile operators case, I think the Dutch Competition Authority reached a settlement. And an interesting case, which I haven't mentioned here, is that the UK authorities have recently dealt with some public announcements, but not in the context of a Competition Act or an Article 101 investigation. They used their powers to investigate markets, to have a look at the cement and aggregate market, which was a tight oligopolistic market where they felt that there were problems with parallel behaviour and transparency on the market. And at the end of a market investigation reference, they've got quite broad powers to impose remedies. One of the remedies they imposed were behavioural remedies, which was that the players on the market were not to make public announcements long time in advance of their prices. So that is a space to watch. It is attracting some attention from competition authorities. Where the information exchange doesn't relate to sensitive price information about future pricing, then the competition analysis is a little bit more complicated. But again, generally, the competition agencies and the courts are concerned about conduct which might facilitate coordination on a market, even if it isn't about exchanging information which is reducing uncertainty about future pricing behaviour. So the analysis in these cases, I'm just going to flip forward to this slide, is very, very fact-specific, both under Article 101.1 and 101.3. And the two most important points to make is that whether or not the information exchange is likely to restrict competition or meet the 101.3 criteria is going to depend both on the market characteristics. So these information exchanges are more likely to be problematic in tightly oligopolistic markets which are transparent, relate to sort of non-complex, homogeneous products, and a fairly sort of stable markets, or where, and on the information that's been exchanged. So if the information exchanged is likely to lead to greater transparency and stability on the market, then that could be problematic. So as an example of that, there's the UK agricultural tractors case, which the Commission investigated a number of years ago. In this case, they weren't exchanging information about price. There wasn't any other underlying anti-competitive agreement, but nonetheless, they were exchanging very sensitive information relating to sales, and which enabled them to see the market shares of their competitors on the market. And the Commission was concerned in this case that the exchange would produce anti-competitive effects and infringed Article 101 because of the very sensitive and what should really be secret information that was being exchanged and the highly concentrated structure of the market. In ASNEF Equifax, in contrast, the analysis was quite different. This was an information exchange between credit institutions about the solvency of customers and the likelihood of that they would default on borrowing. And so the idea of the information exchange was to try and reduce risk of lending to customers that might default, and to try and therefore reduce the cost of borrowing. This was an Article 2.6 reference to the Court of Justice, which, if you do want to have a look at information, how assessment of information exchanges might take place, this is a very good judgment to look at. It gives quite a lot of detail about how the analysis under 101.1 is conducted, of whether these arrangements might restrict competition, and if it does restrict competition, how the 101.3 analysis might be conducted. And in this case, the court was clear that even if the agreement did restrict competition, it was clearly capable of producing a number of significant benefits to prevent over-indebtedness and to create perhaps a greater overall volume of lending, and that those benefits would be passed down to consumers. So although there might be some consumers that might be worse off as a result of the agreement, those with a poor credit risk might not be able to get credit, they might have higher terms of lending, that the majority of consumers perhaps would benefit from more lending possibly at lower rates. But because it was an Article 267 reference, they were providing guidance to the National Court, and they didn't rule on the facts of the case in front of them. Just some, to finish up with some quick conclusions. Information exchanges does cover a spectrum of conduct, from good to very potentially problematic. As competition agencies become more sophisticated at rooting out more traditional cartels, perhaps firms are becoming more sophisticated in the way they try to coordinate their behavior, and competition authorities, if they uncover information exchange which they think is designed to enable coordination in relation to future prices on the market, they will increasingly treat it as cartel activity and impose quite significant fines. The Court of Justice has, as you mentioned, has confirmed in both the Bananas, the Dole appeal, and T-Mobile that these exchanges may be restrictive of competition by object, and so firms need to be very careful. And not only about exchanging information with their competitors, but also receiving information about pricing information from their competitors. And competition authorities are also increasingly scrutinizing unilateral public price announcements. So I'm not sure if you can read that. It's very, very small, but just a few tips for firms to think about, on businesses to think about, be careful in trade association meetings in particular, or if your competitor discloses information to you, you will be treated as having accepted it unless you publicly distance yourself from that information. And if you are exchanging information with your competitors, think carefully about why you're doing it, whether it's necessary, how that exchange might be interpreted by a competition authority if they were investigating it, and who you're sharing it with. Why is it a private exchange? Do you want to share it with customers as well? Thank you.
Thank you, Alison. That was really very interesting and raises, I think, a lot of questions about what firms can and cannot do in terms of information exchange, but we'll come back to that later in the discussion. So, Mike, you're a real crime fighter, so give us some of your experience.
Thank you. Thank you very much. Well, welcome, everyone. This is my first visit to Latvia, and I have to thank the organizers for their hospitality and all the help they gave me. I've enjoyed it tremendously. And so, I didn't realize, here's my slides for tomorrow. That's all right. We'll just leave it like that because it has my contact information, and we'll proceed without the slides today. So my topic is how to detect and prove bid rigging, what you would refer to as bid rigging in contracting and procurement. That's different than detecting large-scale cartel activity and price fixing and market division. I'm talking about local international contractors that have major construction projects who collude and inflate prices and so on. It's different, obviously, than the cartel activity we've been discussing to date, but it's not unimportant. Some of these projects involve billions of dollars, and the procurement sector, the contracting sector of government procurements is huge, sometimes 15 to 20% of a country's budget. So that's what we're going to talk about, how to detect and prove bid rigging and contracting and procurement. And then we're going to talk very briefly about some strategies and tactics that competition agencies, and maybe in cooperation with anti-corruption agencies and law enforcement agencies, can use to try to detect and prove it. And then realizing that the people here today are at a higher level than those that would be expected to do this, maybe some discussion about what type of resources would your agency need, what type of people would they need to hire, and so on to accomplish this. And then at the end, I hope to have time to mention what I think is the single most important development in 15 years of doing a collusion or corruption case literally every day, and that is the coming reliance on electronic tendering, electronic procurement, that sort of thing. Please believe me that I don't have the slightest interest in electronic procurement or tendering. I tried to read a report on it and I couldn't get through the first 10 pages. But what I have a tremendous interest in and was stunned to see is the volume and relevance of the data that those systems will collect and store with virtually no additional expense, virtually no trouble for auditors, investigators, and procurement personnel to access that data, run algorithms, look for indicators of collusion and bid rigging, and use it in a variety of ways. It is stunning to me when I saw it first a month or so ago when I was in Indonesia looking at their e-procurement systems, the advantages that will offer. So we'll talk a little bit about that. All right, I began many years ago as a Department of Justice prosecutor in the United States doing nothing but corruption cases involving organized crime, and after that I enjoyed it. And then I did some litigation, civil litigation in a private firm, antitrust, representing some Japanese companies. And then about 15 years ago, I became heavily involved with the international agencies, the World Bank and UN agencies, and began to manage some of their investigations of corruption and collusion, which they prohibit. And what I was stunned to see when I first arrived at the bank and UN agencies was the level of corruption in development projects. And it's no secret. It's widely acknowledged. The World Bank, for example, in Washington has 105 people that do nothing but investigate complaints about corruption in World Bank projects. And they're overwhelmed. They can't keep up with it. That stunned me to see the level of corruption. What I saw next, which was equally stunning, is the level of collusion. Of course, the bank and these other agencies, a great deal of their funding is infrastructure projects, which are roads and airports and so on. And the reports and complaints of collusion began to come in, and I thought that collusion would be an occasional activity where people seize an opportunity, but in fact it was, in many countries, the norm. And the other thing that I saw, which is very, very important to mention here, is I saw the link between companies engaged in collusion, collusive bidding, one with another to inflate prices, and corruption, and then bid rigging and fraud. Now I have to explain, when I talk about collusion and bid rigging, they're two entirely separate things. Collusion, in my vocabulary, means companies themselves agreeing to inflate prices, submit complimentary bids, exclude competitors. That's collusive bidding. Bid rigging means, in my lexicon, unilateral agreements between one bidder and a corrupt official in which the official and the bidder agree to rig the selection process so that that particular bidder will win. And the indicators are entirely different. The investigative steps are entirely different. And we have to separate them. But at any rate, I saw that in many cases, it was collusion, corruption, bid rigging, if a government official was involved, and fraud, all wrapped into one, which was actually an advantage to us because if it was difficult to prove the collusion, we had other entry points, such as a stronger case on fraud, an easier case on corruption, an easier case on bid rigging. And if we had more time, and I'm going to refer you to some online resources because we don't have time, I put a lot of information online which distinguishes these situations and gives very detailed step-by-step advice as to how you recognize it in the first place and how you respond to it. All right, and I'll give you some examples as we go on. Now, I was very, very happy to hear Professor Fox mention this morning that government officials are involved in these collusion cases. I was happy to hear that because I agree with it. I was a little disappointed to hear it because that was the only thing I could think of that I was going to say that may be of interest to you, and then I had to think of something else to say. But one thing I will say is this. They're not, in most countries, I don't know about Latvia, but in most countries, the government officials are not only involved in it, they set it up. They organize it. They give instructions to the pharmaceutical companies as to how to divide markets and which to provide. They have conferences with the road construction companies to ensure that they're colluding, to inflate prices to make it easier for them to collect their bribes and so on. This I know not from theory. I've done this for 15 years. I've sat with people who were involved in it, who were admitting to it. And it's not rogue government officials. It's the system in many countries. It is the system that when $1 billion is going to be spent on repairing a road network, the government officials and the local politicians are all over that from the beginning. They seize that opportunity immediately to involve themselves in it, to ensure that their favorite contractors will win, to ensure that they get a cut, to ensure that they get their bribes, and so on. And the government officials also cooperate, and you can see this when you do the investigations. The government officials also cooperate to protect the bid rigging firms. For example, if there's an ongoing collusive bidding group, I don't want to call them a cartel because that's a too dignified term for them, but there's the Philippines, for 10 years, for a decade, received billions of dollars of funding from international donors to repair roads, many billions of dollars. Every single contract during that 10-year period was rigged. Every single contract. Every piece of paper submitted as a bid, which would fill the 20 square feet over there, and the bids are this thick for road. Every one of them was simply a facade. Those contracts had been decided at meetings involving government officials and local politicians and favored contractors before the announcement for the request for bids was even published. And all of this organized by the government officials. All right. So we see, I've seen in my experience, this network of collusion, corruption, bid rigging, and fraud in road construction everywhere, in airport construction, in the headquarters of a UN agency, in pharmaceuticals, as I've seen, and especially, and I wish we had more time, especially in major IT contracts. Major IT contracts, and some of these are several $100 million. If you're competing for the hardware and software contract for a government to set up its pension system or to automate its treasury processes, you're talking about hundreds of millions of dollars. And in these projects, the major IT companies, their first default position would be to meet one with another to decide whether or not it made sense to them to collude, in the sense that they would either divide the market, in the sense that if country one was wanting a treasury project at the same time as country two, they considered jointly and openly as to whether or not it made more sense for one company to bid on country one and not on country two, and then to exchange the roles as other projects came in, because they could see more projects in the future. Or more commonly, they would have discussions as to whether or not it made sense for company one to provide the hardware and company two to do the software on this particular project, and then reverse that on the next project. And if they could come to an arrangement to do that, they would do that with drastic inflation in the prices. If they couldn't come to an agreement, then they each would scramble to try to find the most effective local agent. You all know about corruption. You know that most international corruption on major projects is done through agents. And these major companies would then, if their efforts to divide the contracts failed, these companies would go out and try to find the most connected, the most effective agent in these countries. And whichever company succeeded in getting this agent, and there's very, very well-known people in the industry who are very capable, very popular to serve as agents, which are the transition points for the corrupt payments. The other companies that did not succeed in getting that agent would then consider withdrawing completely and not submitting a bid and waiting to the next thing. Now, this is something that I thought would be an occasional story which would occur once in a while, and then I discovered as I got involved in these big IT contracts, that was the norm. That was the norm. And some of these complainants would come to me and say, okay, Mike, you got to look at this. You got to look at this case in far Offistan. I mean, this is ridiculous. These prices are too high. They would say, well, how do you know that? And as I got to know, these are confidential informants, as I got to know the informants better, it's because I sat at the meetings. I sat at the meetings. And we tried to arrange something and we couldn't. And then we were unfairly excluded. There's no honor among thieves, and they didn't honor the agreement, and they kicked us out, and so on. So major IT contracts illustrate, as well as anything, this link between collusion, corruption, bid rigging, and fraud. All right, so let's go back and talk a little bit now, as time remains, about some of the basic detection methods. At the World Bank, which is where I do most of my work for anti-collusion, they don't have a leniency system. They don't have an amnesty system like the US government does, and I understand you do. And so virtually every case begins with a complaint. Most of them are anonymous and so on. And when a complaint comes in, as I said, the investigators at the bank are overwhelmed with the volume of complaints, so it's very difficult for them to decide which complaint merits their attention and so on. So what we decided to do to try to streamline this process is we at the bank informed ourselves and did a lot of research on what are the primary indicators of bid rigging in construction projects, keeping in mind the way that I use the term. And so with the research and with the experience now of 10 years, we identified the key indicators, and the way we use them is not to detect not to detect the schemes, but to evaluate the complaints. So if somebody complains that an irrigation project in Indonesia was the result of collusion, and most of the time this complaint is anonymous because people are afraid to identify themselves, we would use these indicators. We would get the data and use the data to look for indicators to see if the indicators supported the claims. And what are the most common indicators we've seen? Well, I'm embarrassed to tell you some of them because they're so obvious. The most common indicator of collusion in major World Bank projects, which are hundreds of millions of dollars, is physical similarities in bids. Nothing sophisticated at all. You put the actual bids on a table and you see the same formatting, the same typos, the same everything. As I said, it's beneath our dignity to investigate some of these cases. Right? And you would think that they would come up with something sophisticated. But that was it. The number one indicator was physical similarities in bids. All right, number two indicators, same fax numbers on different bids. All right, even I can figure out that's a red flag of something. Although I went to a German company one time, a couple of years ago, and asked them how they managed to win 17 straight water supply contracts in Sierra Leone, Africa. And also, how come their two competitors for every 17 contract faxed the bids from the same fax number as their fax number? The guy didn't even blink an eye. He had an explanation. And then he asked me if I wanted to get a good deal on a Mercedes, and he asked me if I was related to the famous Professor Kramer, which I wasn't, of course, and just basically tried to ingratiate himself to try to get out of trouble. Why do they do such simple things? Because in that part of the world, there's never been any enforcement. There's never been any need for sophistication. Now then, you get into maybe the environment you're operating in, it gets a bit more sophisticated, and so you look at bid patterns. What is the most common bid pattern we see? And we have to use some software for this, especially with local currency, which can be in the billions. The most common indicator of bid rigging in construction projects is bids from different bidders, line item bids, earthworks, that type of thing, that are exact percentages apart. So the winning bidder, the designated winning bidder, remember now the group is met privately and they've decided who's going to win and who's going to lose, the designated winning bidder will bid X. The 5 designated complementary bidders, the guys that agree to submit complementary bids because they're going to be paid or because they're going to get their contracts eventually, or because the government officials tell them that if they don't submit a complementary bid, then they'll be excluded from municipal contracts and other contracts. So they have to bid. But they don't want to spend 3 weeks or a month having their chief engineer prepare a bid this thick, which they know they're going to lose. So what they do is they agree that company A will submit the winning bid and that their bids will either be higher or deliberately defective or incomplete. But they say to the winning bidder, you prepare all the numbers. So the winning bidder prepares the line items and the total bid price that the winning bidder wants, and then the chief engineer or estimator for the winning bidder will prepare all 5 losing bids. How does he do that? He puts the winning line item bids in an Excel spreadsheet, hits a multiplier tab of some obscure number that no one will ever see with the human eye, and that becomes a losing bids. In Bolivia, every bid from the different bidders was exactly 1.343% apart. Now, I'm not a statistician, but I think that's highly unlikely that happened. All right? And we see that all the time. So we've developed at the ICRC some very simple software. It's free. You can get it for free. It's very simple. That has 12 or 13 of these common indicators that you can run your bid data through that, and you can see if bids are exact percentages apart. What are some of the other key indicators? Bids that come in within 5% of the reserve price. Now, this is very big in the academic literature. Some people in academia have made their reputations on publishing these papers. And there's probably 1,000 of them on the internet, literally. If you Google detecting collusion in procurement auctions, it never ends. There's hundreds, literally hundreds of papers. And they all have their different theories. But one of the popular theories is bids from different bidders that come in within 5% of the reserve price is collusion. That's not collusion, that's corruption. Because the reserve price means that is the price that the agency, that is the highest price that the agency will accept in the bidding. It's not the owner's estimate, it's the highest price the agency will accept in the bids. And if it goes above that, then the agency will reject all bids and rebid because they don't have a budget for it. So the bidders know the reserve price, and the winning bidder comes in within 5% of the reserve price because it's been leaked by the government official, as I said, who almost always is involved in facilitating these schemes, in order to allow the winning bid to be as high as it possibly can. Okay. Rebidding patterns, I think this is a good indicator. Companies bid, bids are rejected. Companies bid again, second and third rounds, and then every second, third round bid from 7 or 8 different bidders comes in the exact same order as the previous bid. Highly unlikely. Those are good indicators. The number one indicator for us, though, is sequential bid securities. Are you all familiar with bid securities? Again, not the most enthralling topic in the world. But if you are bidding for a construction project, you have to submit a guarantee that if you're the winning bidder, and you're what they call the lowest evaluated bidder, called L1, and then you will sign a contract within 90 days. In other words, you can't submit a bid, be evaluated as the recommended winner, and then decide to withdraw. And to guarantee that you won't withdraw, you have to go to a bank or insurance company and get a bid bond that says if you do withdraw as the winning bidder, you have to pay a 2% penalty. Now, the only company that has to worry about submitting a good bid bond, which costs some money, is the winning bidder. In a collusive bidding ring, the 5 or 6 bidders already know who the winning bidder will be, so the 5 or 6 designated losing bidders don't need to waste time getting a bid bond. And so they do the sensible thing. They take the young lady who works at the bid bond department of the local bank out to lunch, give her $100 and ask her to forge bid bonds. And she does that. Unfortunately for her, she's also done the real bid bond, and so she gives the forged bid bonds the same date, the same bank, and sequential numbers. When we discovered sequential bid securities, we then went proactive and entered all of the bid security numbers of all the World Bank finance projects in South Asia, and we were hitting cases like crazy. We found sequential bid securities everywhere. And that is an indicator that's very, very hard to explain, especially when they're not only sequential but forged. All right, I've also said there's a difference between bid rigging and collusive bidding. If we're looking for indicators of bid rigging, they're entirely separate. But if you want to see if a government official is involved in your collusion case, what you will see is not only the bid patterns of collusion that I've just described, but you will see the original L1, which is the lowest evaluated bidder. You will see the original L1 or L2, the second lowest bidder, disqualified by the bid evaluation committees, which are the government officials, for inadequate reasons. And that's how the government officials are keeping the divers, people we call a diver. A diver is a real bidder that tries to dive under the cartel, keeps the divers out. So our software programs and others will identify the involvement of the government officials and the agreements among the other bidders. All right, so these are simple tests. They go into some software programs. As I said, the problem is that you need data. And it's very hard for us, since our projects are all around the world, to collect the data. So someone complains that an irrigation project in Ethiopia, the prices are too high, he thinks there's collusion. We have to get the actual paper bids from Ethiopia, and it just doesn't work. However, that's changing with e-procurement in a very big way. And so in addition to evaluating these complaints by looking at the bid patterns, and by the way, if you send me an email, I'll send you the link, there's dozens of these indicators online, dozens of them, that I can give you a website that identifies these different indicators for different schemes. All right. So it turned out that evaluating bids was very cumbersome and tedious, and we couldn't get the bids, so then we would turn to another methodology, which is we did background checks actually, on the different bidders. Now you think, now there's a no-brainer. I mean, if you're not doing that, you need to turn in your investigator's credentials. But surprisingly, a number of agencies were not. And so, as you know, many losing bidders in complementary bidding schemes, again, say road constructions, the losing bidder doesn't actually exist. It is a clone of the winning bidder, or it's just a shell company that's organized to submit bids. In some cases, even the winning bidders don't exist. In the Philippines, again, in a famous case, the company that won most of the contracts over a 10-year period was nominally headed by the best friend of the husband of the president of the country, and the best friend won a lion's share of bids over 10 years, which were and the bid patterns indicated collusion, but no one actually checked to see the credentials of the winning bidder's company, and it turned out the winning bidder, and I'm not exaggerating, actually did not have a company. And the address was his penthouse in a condominium in Manila. I'm not exaggerating. They never thought it was important to do any background checks on companies, or to see, in a case in Indonesia, that one of the bidders was located at a Chinese restaurant. Well, this is great, except they weren't acquiring Chinese food. All right. As I said, we're not dealing with the most sophisticated people here, but we are dealing with some big losses. Okay? Yeah, it's true. All right, so finally, what do we decide to do? Background checks are good, and now I see I'm running out of time here. We decided that, we discovered that, like every other investigator, you need witnesses. You can't do a collusion case, bid rigging, corruption, fraud case, just from bid patterns, just from circumstantial evidence. You need witnesses. And the problem we ran into at the very end of our work recently is we didn't have traditional investigative skills. We did not have people assigned to collusion and bid rigging cases who are investigators. They didn't know how to interview people. And I don't mean cooperative witnesses. I mean they needed to get an insider who participated in the scheme. They needed to get that person to cooperate. And they couldn't do it because they were, and I don't mean this disrespectfully at all, they were junior and they had economics background. The bank hired economists who are 23, 24 years old to do bid rigging cases because they thought that's the work of an economist. No, what they needed to do is travel to Kuwait to interview a losing bidder who submitted a forged bid security and get that losing bidder to admit that he did it. And they couldn't do that. So what do you need? I know I'm going to finish in just 25 seconds. You need to know the links between collusion, corruption, bid rigging, and fraud, because it gives you various entry points. You need to know the schemes and all the indicators. You need some analytic tools, such as software, and the World Bank is working on a very sophisticated background checking tool for companies. And you need standard investigative tools. And e-procurement is coming, and what's wonderful about that is, as I said before, it collects masses of relevant data that we can exploit tremendously to identify indicators of collusion. I think it is the single most exciting prospect. I'm doing a contract now in one country. I look forward to doing more. But this is the thing I'm most excited about in 15 years. So thank you very much.
Thanks, Mike. That perhaps sounded funny and entertaining, but it's of course very serious. I think the only thing we can be glad about is that some of the bid riggers are not very sophisticated and therefore continue to be caught, even if it's not by economists. But let's talk about it later. I just go down the line and then we move to Dan.
Okay, also I will start by thanking the Latvian authority for having me here to discuss what we are doing in the same area. It will be pretty hard to follow Michael's discourse there. As Alexander was saying, this is not funny at all, even though it is sometimes entertaining to hear those stories. Now, we in the Swedish authority, we have a dual responsibility. We are an antitrust authority, but we're also the investigative and enforcement authority for public procurement in our country, which is not so common among the European competition authorities. And I'm going to speak a little bit about the advantages that we think we have from that and how that it sort of interlinks with what the previous speaker was telling you. So being in the procurement business, we have a natural reason to be very much in contact with procurement officials across the country. at least in my country, public procurement is a very there are many people who do procurement. We don't have a centralized system, so it's a very decentralized system. I think there are about 10,000 procuring entities in Sweden. So you can imagine that there are lots of contracts going on. And it is a very important activity. It represents in Sweden somewhere between, I'd say, 17 and 20% of GDP, depending a little bit on how you count. And I think that's more or less on EU average. So I think if you have 11 here in Latvia, you're sort of a little bit on the low side. But nonetheless, we are very much aware that these public tenders are very much prone to cartel and bid rigging activity, collusion, corruption, illegal direct awards. There are many things that go around, and I think we do also feel that there is a pattern that if there is some unlawful activity of one kind going on in a particular contract, you may very well find many breaches of different laws going on surrounding that contract. So this is something that we are very much interested in, and something that we try to develop a better approach and means to suppress, both to actually find the offenders, but also to make it less appealing for people to engage in such behavior. And how does one go about doing that? I think this is an area where you have leniency, of course. We have a leniency program as well. As Rita was saying, you don't always have a long queue of people coming in, so you need to be active in proactively changing a little bit the odds of detection there. And that's what I'm going to talk about here, about our screening project. So there are many things that affect the willingness of cartelists and wrongdoers to engage in unlawful behavior, but the risk of detection and the gravity of the punishment that they would face if they are caught, and of course the rewards of engaging there are sort of main themes. And I think we have at least some ability to a little bit affect the calculations that cartelists are doing by being trying as good as we can to use proactive methods, talk about it as today, and in all the forums that we can, we make a big effort in reaching out in particular to trade associations. We invite ourselves to speak at trade association meetings and hoping to at least offset some of the people who might otherwise have entered into these kind of behaviors. So for the last couple of years, we have actively increased our work in this field, and we started also by looking at, so the difficulty is where to look, where in the economy should you be looking. So what we did in our first screening projects was that we had, you get some information, you get tips, you have industry people who tell you things, you read things in the press, you hear things from sister agencies that are looking at other parts of the law. And you collect a little bit of indications here, there, and everywhere, but you may not have enough to launch a proper investigation or to go on a dawn raid or something. So what we initially did was we took a number of such areas that we had information about, and then we went to see what information was there in terms of bid records from that sector. And sometimes the material is rich, and sometimes it's not so rich, and it's getting better. And with e-procurement, as Michael was saying, it will get fantastic. But we're not there yet. So we used that, and we used some screens, and we looked at areas where we already knew that there was perhaps something wrong, and that it is a helpful means of at least enabling you to better prioritize which of these things to continue with. And we have done a few cases over the last year that actually have come from, started with tip-offs that were not sufficient in themselves, but then continued with screening activity in sectors and developed it into a sufficient basis to do a dawn raid, and then actually found something and prosecuted the cartels. So we've already heard a little bit what these screens are. They are methods of flagging indications of collusive behavior in markets using economic theory and statistical analysis of data, and data is the key issue here. We have, in our most recent project now, we try to get more advanced, so we have actually gone out and bought from a private sector company a data set which consists of almost 100,000 public contracts procured by various procuring entities in the period of 2009 to 2013. As you can imagine, that's a lot of data. And each of these data points then contains information about who was procuring this, the date of the contract, the type of product category, selection procedures, participating firms, winning firms, and if we're lucky, there's bid prices and geographical regions. So that's a lot of variables, and we use all of that to test the data and to find patterns. Like Michael was saying, you can find many different kinds of patterns. Goes from sophisticated to not so sophisticated, perhaps. But things will be flagged by this. We've been trying to develop a program that sort of flags suspicious situations where one firm is not participating in certain types of bids, for example, in an industry, where you can see signs of rotations between who is offering the lowest, the best price, regional divisions of markets, also these, as Michael was saying, the percentage points. We have had situations where the winning bid was X and everybody else was either half or a full percentage point above that price, and those kind of situations, of course, then get flagged, and then that gives you a reason to continue to look into those situations, and it might be sufficient at some point then to go out and seek more actively information. But as I was referring to before, the real problem, the real issue here that we try to develop is having sufficiently good data sets. So it really depends a lot on what is put into this data. We are getting much better at cleaning the data and making it useful. We have made suggestions to government in terms of obligatory data that procuring entities should have to record in terms of all the contracts that they are procuring, and I think that's something that we are continuing to understand better, and I think that also might be something that would be worthwhile to discuss on even a European level, because at the end of the day, we are actually using European directives for procurement. So when the interlink between procurement and detecting and making something about bid rigging is that close, I think this is an area where there is lots of scope for us to work together for the future. So I think I will stop there. I see that my time is nearly up, and I'll be happy to continue in the discussion.
And finally, Adam.
Thank you. Good afternoon again. Thank you for inviting me to this event. It's a great honor to speak here. I just want to give you a quick overview of what's happening in detecting collusive tendering in Poland. here it is. Okay, very good. So a quick overview. Like in many other countries, this is a significant share of the economy, particularly with the inflow of EU funds. This has become an important aspect of modernizing Poland, and obviously some really high-profile public procurement for roads, infrastructure, and so on and so forth. So there's a lot to do, and the competition authority since 2011 basically intensified its work on collusion in tendering. The biggest cases we've had are those. So by the standards of the Commission, of course, these are not necessarily huge fines, but many of these on the local market, these were significant collusions. I would like to stress that we've got 9 regional offices, and some of these tenders, some of these collusions took place in really local small markets, but nevertheless their impact on the local market was very often significant. In the Polish legal framework, we have a twin system. We have when it comes to managers and natural persons who are involved in bid rigging in its all aspects, so both corruption or just collusion or bid rigging as such. There are criminal sanctions for this. And on our side, as the competition authority, we look at on the corporate, and this is part of the administrative procedure, and we impose fines on corporations rather than individuals. Well, that creates a whole lot of problems about which track is more important and an exchange of information, but this is something I want to move on later in the presentation. So how do we detect these cases, or how they are detected in general, because again, other agencies are involved. So our primary source, or the primary source, as was said earlier, a lot of this activity is about corruption, and of course there is a specialized agency now in Poland which focuses on official corruption, and a lot of it has to do with public procurement, of course. But there is also the Internal Security Agency. There is a separate body that oversees public procurement. And of course, you also get signals from the market. So sometimes it comes from competitors who lost. Sometimes you get whistleblowers. Sometimes we even find indications that something is wrong in the press. But what we also found out is that it's very important to look at patterns and look at data available. And it was discussed earlier today that leniency plays a role, although from the numbers I will show you in a minute, actually leniency in our case has not proven very successful, but in this particular area. So this is how complex the system in the end is. UOKiK is, so the Polish Competition Authority is marked out there. But actually you have lots of agencies who circle around this. And of course, when you have lots of agencies circling around this, the exchange of information and the timeliness of the exchange of information is actually a major challenge. If you look at these we call it competition network, and we try to intensify cooperation and exchange of information. We sign agreements with them, but it's difficult because all these agencies prioritize different things, and sometimes even when they collect evidence, they're not necessarily prepared to share it early enough with us. I will come to that in a second. But if you look at these agencies, so for example, and different sources of information about collusion, we've had 2 cases of leniency. 7 of the cases that I showed you at the beginning, 7 came from competitors complaining. About the same number came from from the ordering authority or the public institution that was running the tender, and none came from our own data mining. So it just, to me, it just proves the point that you actually have to do a lot of your own stuff to have an efficient program. And going back to the obstacles, so again, the fact that so many agencies are involved in this, and very often they prioritize different aspects, because corruption is politically also very attractive. Fighting corruption, in particular in the new democracies, is very often a very important point. So this takes precedence, and very often you have law enforcement officials who go on searches. They don't even look for evidence that we could use in our administrative proceedings. So making them aware of the fact that once they investigate, we need to get their stuff is sometimes not that clear to them. And there are formal obstacles. There was a ruling of the Constitutional Tribunal that evidence from surveillance obtained in one investigation cannot be used in a separate investigation, even if it has either criminal or administrative infringement in it. And the narrow interpretation of that is that even if there's a wide collusion bid rigging investigation, if this is corruption, then the collusive element cannot use the evidence collected in the, let's say, anti-corruption proceedings. So these law enforcement agencies are first sometimes quite reluctant to share evidence, not to compromise their own investigation, or to ensure that it later stands up in court. And there's no culture as well of sharing intelligence. So this is something we need to focus on, and very often we were, particularly locally, if you deal with local prosecutors or local law enforcement officials, they are not even aware of the fact that there is a separate administrative tract for collusion in procurement. So they don't look for evidence, they don't pass it on voluntarily, and so on and so forth. So how are we trying to overcome these obstacles? I see I have 2 minutes, so I should manage to wrap up. Well, one key change that was just introduced earlier this year is that the overall in the competition law, we extended the limitations period to 5 years from 1, which means that now some of these law enforcement agencies will be able to conclude their investigations and pass on evidence early enough for us to act. We have had very high-profile cases where there was both corruption and collusion in tender, which we couldn't pursue under the old regime because it expired, the statute of limitations came in. So there was a criminal conviction, but we couldn't complete on the corporate side in the administrative proceeding. And we've had some, particularly with road tendering, we had a number of high-profile cases like this, which would have been caught had we earlier introduced this 5 years statutory limitation period. And then we, as I said, we were trying to encourage law enforcement agencies to exchange information with us. We signed relevant agreements. We tried to persuade the prosecutor's office, the head prosecutor office to conduct training, and we're actually doing some training for prosecutors where we try to show them that when they collect evidence, they should also take the administrative part into consideration. And while collecting evidence of, let's say, corruption, they can also collect evidence for us. We have also run a program for local governments, for the local authorities, and under specific EU programs, where EU funds are used for public procurement, so that we get more data and that we can, together with other agencies, look through this data. So all in all, I can say that for us this is a mixed picture. We've had a number of cases, so it's obvious there's some activity. We have a feeling that there is much more we can do here, but we will need better coordination with other agencies unless there is this smooth exchange of information. Then obviously some of these efforts will be hampered in the future. Thank you very much.
Well, I think it's a fascinating topic also because it touches on the interaction between criminal and civil enforcement, and I think that's a very challenging component, in particular for those agencies that are doing administrative enforcement. And Adam has just illustrated this by all the cooperation agreements that he has to sign. Well, I have a couple of questions, but I don't want to monopolize, abuse my dominance here, so I leave it to the floor first, and only if you are completely silent, I will fire my own questions. So there's a mic. Yeah, in the middle.
Hi, I'm Nuno Carvalho from the Portuguese Competition Authority. In Portugal, we have mandatory electronic public procurement for a couple of years now. So there's a centralized database, and we're looking to coordinate with the entity which has this database to look into infringement. Of course, we don't have dual capacity of competition analysis and bid rigging in your lexicon. So my question is, are there ways of, when you're looking at this data, to weed out what is typically bid rigging, corruption cases from collusion cases? Because, I mean, if we can't investigate it, it's just too much. I'm not saying that somebody else shouldn't investigate, but we need to be sure that we're using our resources correctly to hone in on those collusion cases.
Yes, I think there is. As I said, online materials I'll be happy to link you up with if you contact me by email. Provide separate descriptions and list of indicators and investigative steps for each scheme. So the indicators for collusion are going to be different than bid rigging. Now, of course, bid rigging is divided into 10 or 12 separate schemes itself. Unbalanced bidding, which is a huge problem if you're familiar with unbalanced bidding. It's very sophisticated bid rigging schemes used in construction projects, very hard to detect, but with a computer you can do it. If you've never heard of unbalanced bidding, send me an email, I'll explain it to you. And there is some confusion. There are some indicators where it's hard to tell what it indicates. Also, there are other indicators that are too ambiguous to be of much use to you, which is why in our work we don't use indicators to detect the fraud, we use indicators to evaluate the complaint. Because the complaint is very specific. You'll say, I should have won this contract, but I didn't. And the procurement bid evaluation committee did these bad things. With that type of focus, you can evaluate. But before I ramble on too much here, there are very stark, useful indicators for bid rigging and collusion that relate to separate schemes that generate follow-up steps that are very useful, especially if you can build these fraud filters, we call them, into your e-procurement systems. And send me an email, I'll be happy to share that with you.
Okay. Any other questions? Yes?
Yeah, Katharina Kraus from the German Competition Authority. I would like to make a comment also to your experience, Mr. Jasser, from Poland, because we have quite similar experiences in Germany concerning criminalization of bid rigging, because this also has caused the same problems in Germany concerning the mix of competences, and which really complicates our prosecution of bid rigging and collusion in public tenders. And I wonder whether, what is the position of your legislator maybe, because I have the impression that the legislator could solve some of the problems, at least that you mentioned. Like we are now trying to influence our legislator that there is a legal obligation for public prosecutors to pass on information to us about, for example, about suspicion concerning bid rigging or something like that. Because the other way around in Germany, it's already, we have, as competition authority, we have to pass on information to public prosecutors concerning suspicions concerning bid rigging or corruption. Otherwise, it would be even an infringement of criminal law if we wouldn't do this. So this is quite a big incentive, of course, for us to be quick and pass on information to public prosecutors. And so if it would be, for example, the other way around, or also the use of evidence or something like that, how is the position of your legislator here?
It's probably hard to describe the position of the lawmakers on this, because I'm not sure that this problem has appeared on their radar screen yet. I think there's a lot of focus on the sort of criminal part. And obviously, as was said earlier, very often it's a question, which is the priority? If it's evident corruption and particularly big amounts of money get involved, then everybody's priority is to get the criminal track done properly. And then suddenly this collusive element where the fine is going to be on the company when actually the personal involvement was overwhelming, then it's hard to explain to people that this is also very important to pursue this, and that systemically it is important. Ideally, what I think should happen in this is that actually you do these investigations jointly, so that there's some kind of an early warning mechanism between these agencies, and they're legally obliged to cooperate on this, and maybe even create common teams that together investigate these cases. But I don't think we're anywhere near that in terms of the legal system. Just before I became president, the law, or just as I was becoming president, our basic law was amended. So I think we will be reviewing it within the scope of 2 years, and this could be part of the proposals that we are going to be making. We also are going to seek clarification on what kind of evidence we can use, and that this transmission of evidence should definitely be made easier. But we will be making these proposals as part of the overall overview of our competition law.
Done?
Yeah, maybe just to react on the same question there. I think we are here talking about national procedural law, which will be different in all of our member states. So that's the first comment, that you as a competition authority, I think you have a lot to benefit from actually just learning your country's procedural framework and what you can and what you cannot do together with sister agencies. It may not be something that the sister agencies have ever thought about. They may very well know very little about competition law. They may not be so interested in competition law. They are often, I think, much bigger than the competition authorities, and they have, if they are like the tax authorities, they handle a lot more money than we do. So I think, and the anti-corruption people, they are often, at least my experience is that they are understaffed, and they have a lot of work to do. So I think in our case, we are very much taking upon ourselves to become well aware of the system, and to actually invite ourselves to the sister agencies and to try to explain the benefits of working together and how we think we can work together within the legal framework that exists. So, for example, with the prosecutor against corruption, we have found a solution that we cannot exchange freely classified information between the two agencies. But we do meet and we exchange on a no-name basis suspicions about industries that can sort of prompt the other one to look more deeply into indications that one might already have. So it's as always in fighting cartels, you're trying to put together a puzzle. And just having that extra piece, even on a sort of anonymous basis from a sister agency, can progress your case.
I fully second this opinion. I mean, in the last 6 months, we've agreed to exchange liaison officers. So at the key agencies, there's a specific prosecutor or an official with whom our people can get in touch on a regular basis. And with the Prosecutor General's office, we have every quarter we have a meeting where we go through a number of cases and we ask them if they can accelerate the transmission of data. And on 2 specific cases, it actually led to decisions. So you can do it. Of course, if you change the legal framework, you could always theoretically improve it, but I would agree that first explore what is there and what are the possibilities of increasing cooperation within the existing framework, and only if there are obvious gaps, then maybe you need to change the legal framework.
All right, we have time for one more question. Let me fire then, if I see no hands being raised. Okay, let's take the definition that you made, Mike, between collusive bidding and bid rigging. For you, the bid rigging are cases where there are individuals involved, so it's basically a criminal type of situation. But what if you are doing this screening analysis, you're using the indicators? I mean, the standard of proof for a competition type collusive case is very high. I mean, Alison has talked about the wood pulp case law. So if you have done your screening on the basis of indicators, okay, you may have a potential case, but then you need to prove it. So how to prove a purely collusive case? So how do you go from the indicators to the proof? Is a question for you, Mike, but maybe also for Dan with his screening device.
Well, I'm glad you asked that because it's something I didn't mention, and I should have when I spoke. My clients, the World Bank and UN agencies, have no law enforcement powers. So if we detect circumstantial evidence of collusion, we cannot use that as probable cause to ask for a search warrant. We can't conduct a raid. We can't compel people to come in for interviews. And so that's why I said we have to use some strategies. For example, briefly, in one of our cases, if we discover a losing bidder has submitted a forged bid security, that in itself is a fraud, and under the World Bank rules, that bidder can be debarred, declared ineligible, which is all we can do. And so in some appropriate way, we will approach that person who submitted the forged bid security, and in a proper way, not threats or intimidations, but point out to that person that they can be debarred for submitting a forged bid security. It takes a lot of experience and skill to do that, which the junior people don't have. But if you do that, this person can be induced to cooperate and say, okay, well, I'm a little tiny enterprise here. I'm instructed by the government that I have to do this or I'm declared ineligible. And so she then admits it, gets some leniency, and then provides the emails from the winning bidder, which incriminates the winning bidder. The winning bidder is now in trouble. The winning bidder confesses, as all people confess. They confess by saying, I admit it, it's somebody else's fault. And the winning bidder says, I had no choice, the government officials instructed me to do it, and I had to pay bribes. So we have to, and so there's actually cases with some skill, you can go up the chain, and even the winning bidder who paid the bribe will get some benefit by pointing out that it was extorted. All right. So that's how we move from circumstantial evidence of indicators or patterns, step by step, trying to use that to obtain the cooperation of an insider based on that information. But if we had law enforcement powers, we would use it merely as, not merely, but primarily as probable cause to ask for a search warrant, at which point we would then see the emails, we'd see the communications, and we'd be on our way. Yeah.
Dan, is that how you would do it?
Yeah, I think we generally would use it as a prioritization tool. If screening indications point in the same direction as other circumstantial evidence we have from other sources corroborating the same sort of indication, then that would probably jointly constitute probable cause, and we would get a search warrant from a court and we would just do a normal investigation. And I think that's probably at the moment the biggest use we can have of this to confirm suspicions that otherwise are not sufficient for us.
Okay, well, the flashlight is on. We have our coffee break from 3 to 3:30, but I think this was very informative, a very interesting session. So give a big hand to all the panelists, please. Thank you.